Hi, everyone. Thanks so much for joining us. As everyone gets settled in and comfortable, I'm going to go over a few housekeeping items before we get started. One of them is that this webinar is going to be recorded. So if you've registered for today's event, for those of us who are here live, the recording will come out after. Even if you registered and could not attend, there will be a recording made available after we conclude today's webinar. Another item is that we're going to have a private chat feature, so you can ask questions to any of us during the presentation, and then we'll have an opportunity at the end to go over all your questions. And then last is that Jenny here is going to be putting up some polls throughout the presentation, so keep an eye out for those, and we'll be asking some questions along the way. So again, thank you all for being here. I am joined by Jenny, our marketing director at SJF Law Group, as well as Tiffany Caminali, our residential realtor. The name of our webinar today is Probate and Property 101, a joint perspective for families and realtors. So Tiffany and I are going to be talking today about real estate and the probate process, some things that we see and some ways that you can avoid potential headaches, and everything about probate and property. So without further ado, a little about me. I went to law school at Nova Southeastern University for my JD degree, and then I went to the University of Miami to get my LLM, my master's degree in estate planning. I'm a senior associate at SJF Law Group. I help clients with estate planning, probate, and trust administration matters. One of my mottos is that I help clients to plan ahead before they're dead. And with that, I'm going to pass it over to Tiffany.
Hi, guys. Tiffany Caminali. I have been selling real estate for over 20 years in South Florida, including the Tri-County area. I'm a broker associate with RE/MAX Select Group here in Parkland, Florida. I specialize in listings, buyers, and relocations. I hold a degree in culinary management along with business and marketing. I am an active volunteer and board member on Nicole's Cardiac Kids Foundation.
Awesome. Well, Tiffany, thank you so much for joining me today. I'm excited to hear your perspective on the realtor side about real estate in probate. So let's get started. Okay, so the first thing I want to talk about is, what is probate? Probate is a court-supervised legal process after someone passes away, where an estate is opened in court and it begins a process for identifying the assets of the deceased person. We call that the decedent, paying their debts and distributing their assets to their beneficiaries. Probate is not always necessary. It depends on how things are titled, whether they have beneficiary designations. So some examples of property that doesn't pass through probate, for example, assets that are jointly owned with right of survivorship, with real estate or bank accounts or any type of asset where you see two or more people on title and they own with right of survivorship. That means that upon the death of one joint owner, that asset passes automatically to the surviving co-owner. So it avoids probate on the death of that first co-owner. Assets that have a designated beneficiary, so like financial accounts, for example, things that have TOD, POD, or ITF designations. POD is transfer on death, POD is payable on death, and ITF is in trust for. Those types of assets that have that kind of designation will pass automatically to that named beneficiary outside of the probate process. And then last example is assets that are titled in a revocable trust. Anything that is held in a trust avoids the probate process because it's held in this trust structure. It's owned by the trustee, avoids the court process, and avoids that judicial oversight that's seen in probate. Specifically to what we're talking about today, so title to real estate and how real estate passes through probate. Before we get further into that, I'm going to talk briefly about different ways to own title to real estate. Kind of talked about this one already. Joint tenants with right of survivorship. That's 2 or more people owning. The property goes 100% to the surviving co-owner upon the death of one co-owner. Tenants by the entirety property. This is like joint tenancy with right of survivorship, but this is for married couples, only for married couples. A lot of creditor protection here with tenants by the entirety ownership. Third, joint tenants in common. This is where it's as if, let's say there are 2 people on title to a property and they own as tenants in common, or the deed that they took title to doesn't clearly say with right of survivorship. If you're missing that key language, the default is that you own that property with that other person as a tenant in common. And it's if each person owns 50% of the property. So if me and Tiffany own a property together as tenants in common and I pass away, my 50% goes through probate. If there's no other planning in place, Tiffany keeps her 50% and then potentially owns this property half and half with my heirs or who I've designated in my will. Then last, if you own property in your sole name, this is where also probate comes into play. So if you own as a tenant in common or you own a property in your individual name, that property is going to go through probate upon death if you don't have any other planning in place. So next, wills versus no will. A common misconception, something I hear all the time from clients is, well, I have a will, so why do I need to go through probate? I thought the will meant that I didn't have to go through this process. And the truth is that that's actually the opposite. It's a big misconception, big misunderstanding. Having a will doesn't take your property out of probate. It only controls the probate process. So for better planning, we'll talk about a little bit more at the end, you're going to want to consider some other options. The will only directs who is appointed as the personal representative of the estate, who the beneficiaries are, what powers the personal representative has. Not going to help you with the probate process, just directs how that process goes. So if someone passes away and there are assets or a piece of property that needs to go through probate, the next question is, okay, did that person have a will or did they not have a will? The will say who the beneficiaries are. If that person died without leaving a will, that's what we call intestacy, or we look to the Florida intestate laws, intestate statutes. And the Florida statutes provide a default inheritance scheme. So when you look to Florida statutes, you have spouse, descendants, grandparents. It creates this hierarchy of beneficiaries and what the legislature presumes the default inheritance scheme to be. Sometimes this is really in contrast to what people actually want. And this is why even sometimes a simple will, even though it's not taking you out of probate, can be really beneficial, especially when, you have homeowners who are maybe estranged from their parents or their children, or they have specific beneficiaries that they want to leave assets to. A will in that situation can oftentimes be really helpful. I'm going to talk about homestead now for a little bit. And homestead in Florida, really when you talk about homestead, there are 3 main issues. The first one is the tax exemption, right? The homestead exemption that you get on your property, and that's the cap on the assessed value or how much the assessed value on your property can increase for tax purposes. Second homestead issue is the homestead protection from creditors. So your primary residence is protected from creditors with very, very few limited exceptions. And the third homestead issue is the restriction on devise. And that's what I'm going to hone into now on this slide. So restriction on devise. So devise means that you're leaving your property by will or trust. It's a bequest. There is a limitation found in the Florida Constitution with respect to who can inherit someone's homestead property, their primary residence, when the owner dies. And the rule is that if you are survived, and this is when you own homestead in your sole name, that's an important distinction to make. So if you own a homestead with your spouse or with someone as joint tenants with right of survivorship, these restrictions on devise are not going to apply. This is only when you own property in your sole name. So if I own a property in my name only and I am married and I pass away, I'm survived by a spouse, I cannot leave that homestead property to anyone other than my surviving spouse. Same thing if I have minor children. So if you own a property in your sole name and you're survived, or you have a spouse or minor children, you're not free to leave that homestead to anyone other than those people. The Florida Constitution puts a heavy protection on making sure that spouses and minor children are not disinherited from homestead real estate. If you do own a property in your sole name and you are survived by one of those people, and let's say you make a will and say, I leave my homestead property to my friend or whomever, even though that's written in my will, that's going to be what we call an invalid devise, because I'm restricted based on my marriage and my minor kids on who I could have left that to. So the result is the property goes through probate. My surviving spouse gets what's called a life estate in the property, which is the right to live in the property, use it, occupy it. And then upon the death of my spouse, the house goes to my descendants, to my living descendants. This issue with homestead is oftentimes very problematic, especially with second marriages. I get a lot of questions when people own property in their own name and they're like, well, I owned this property before I got married, or, my spouse has nothing to do with this property. It doesn't matter. That's how the constitutional restriction works. So even if, take the example, for example, where you have someone who bought a property, then they got married, but that spouse never got added to title. If that person dies, this is the result. So again, this can be really problematic when second marriages are involved and there are children from outside of the current marriage. So this is definitely something that people should be discussing with their estate planning attorney and making sure that they're properly advised on this restriction and that they're putting the right plan in place to make sure that they have an estate plan that aligns with their wishes and works the way that they want to. One last thing I'll mention about homestead is that spouses can waive homestead rights in writing via a marital agreement, whether that's a postnuptial agreement or prenuptial agreement or any kind of marital waiver. Okay. So next, this slide is talking briefly about the two main types of probate administrations in Florida and some general timelines on each of those administrations. So starting with formal administration here on the left, this is full-blown, full-length probate administration. And a formal, as we informally call it, is necessary when the value of the assets that are passing through the estate exceed $75,000, or where there's a situation where a personal representative needs to be appointed. And I'll kind of talk a little bit more about that in a few minutes when we move on to summary administration. Formal administration can take anywhere from 8 to 12 months and even longer. So generally 8 to 12 months, you have personal representative appointed. There is a creditor period during formal administration where the personal representative is responsible for notifying your creditors and satisfying debts, giving creditors an opportunity to submit claims for payment in the estate. Contrasted with summary administration, this is a shortened, abbreviated version of probate necessary or available in some limited circumstances. Varies a little bit, county by county, but it can take generally anywhere from between 3 to 4 months. Summary administration is available when the person who passed away has been deceased for over 2 years, regardless of the value of the estate. So if the decedent has been dead for over 2 years and now probate is commencing, you can run the estate as a summary administration. Or if it's within 2 years from date of death, you can do summary administration when the value of the assets going through probate is less than $75,000. And this does not include the value of exempt property. So for example, homestead is considered an exempt piece of property and the value of the homestead doesn't count towards that $75,000 threshold. A distinction here with summary administration is because it's such a quick process and it's a shorter version of probate, there's not a personal representative appointed. There's a petitioner who files a petition with the court, discloses the assets and who the beneficiaries are. Creditor claims are addressed, and then the judge signs an order at the end, an order of summary administration, and the probate's closed. So no one is appointed by the court to be the personal representative, the executor of the estate. If you are in a situation where you need a personal representative appointed, then you'll need to do formal administration. Selling property during probate and potential problems. So as we just talked about, in summary administration, there's no personal representative. The judge signs an order at the end of that summary administration process, and that is the beneficiary's proof of ownership on the property. So take the example where someone passed away, the only asset in the estate is a piece of real estate. When the judge signs that order of summary administration at the end of the process, that signed order is the beneficiary's proof of ownership on that property. There's not a new deed recorded or prepared or anything like that. That order is what they'll provide to Tiffany and realtors and anyone that they need to show proof of ownership to. And then that signed order means that title vests in the beneficiaries and they sell the property if they are selling in their personal names. Title passed to them and then they're selling individually. In formal administration, again, a personal representative is appointed and the judge issues letters of administration. This is the court-issued document that shows this person has been formally appointed as the executor of the estate and they are now authorized to take action on behalf of the estate. You can list a property for sale during formal administration. The proceeds of sale during the probate process go into an estate bank account until they can be distributed to beneficiaries. This is typically after the expiration of the creditor period. Some potential problems with selling property in probate is if the letters of administration are what we call restricted. When the judge issues those letters of administration and appoints someone to be executor of the estate, they will sometimes restrict the letters in that the judge will say there cannot be any sale or transfer of an estate asset without prior court approval. So sometimes this can cause some delay. This scares buyers sometimes. Another potential problem is selling when there are multiple heirs or multiple beneficiaries. I've seen this oftentimes cause delay. There's a risk of not everybody cooperating. I'll talk a little bit more about how to potentially avoid that through a revocable trust. Other problems are mortgage payments, association dues, and other expenses that are time sensitive. Mortgage remains in the name of the decedent. So sometimes I have clients who call mortgage companies to try to find out how to make payments or how to get information from the mortgage. And the person tells them, well, that person's deceased. We need a personal representative appointed, or we need, we can't talk to you. And that can oftentimes be very frustrating. And last point, again, buyers often don't understand probate and sometimes back out when they hear that there's a probate process going on or that they need court approval. How to keep your property out of probate. So let's start with the left. So deeds, as we kind of mentioned before, if you own property with someone as a joint tenant with right of survivorship, that property will avoid probate upon the death of the first joint owner because it passes automatically to the surviving joint owner. If one dies and the second one is still on title, then it would be subject to probate upon the second death because now it's a property that's owned in someone's individual name. So they need some more planning in place. I made a note here, beware of adding kids to title. It's often not a good idea. I have a lot of clients ask me about this, and this comes up really often in consultations and meetings. It's not a good idea to add your kids to title to your property for several reasons. One is you're making them a joint owner on your property. You are exposing your primary residence to all of your kids' potential problems. You're not getting the full step up in basis for capital gains tax purposes if your child, after your death, wants to sell that property. So oftentimes not a good idea. I definitely recommend speaking with someone and finding a better option that accomplishes what you want to do, but is a little bit more protective. Life estate deeds, often used or referred to interchangeably as ladybird deeds. This is a special type of deed available in Florida where you can keep the property in your name during your lifetime. So you hold on to a life estate. And then the deed names remaindermen. This is the beneficiary or beneficiaries who inherit the property upon death. It's cost effective, avoids probate, but for some other planning or for some better planning, I typically recommend using a revocable trust. So you transfer your property to the revocable trust. During your lifetime, you retain full control and authority over the property. And then the trust has very specific terms about upon your death, who does this property pass to? The trustee can sell that property without needing probate, without needing court approval. And the trust offers better protections to the beneficiaries that are not otherwise available if you leave it to them outright. For example, protection from creditors, protection from spouses and bad marriages, if beneficiaries become disabled or incapacitated or on any kind of needs-based government benefits. Revocable trusts are a great way to protect the inheritance from all these potential bad things. One thing I wanted to point out here with the revocable trust, this is often a great tool when you have multiple beneficiaries that you want to benefit, but you want to name one point person, right? So we talked a few slides ago about how where there are multiple heirs, sometimes this can cause some delay and you have a risk of uncooperation. Contrast that with when you use a revocable trust, you name one successor trustee. That trustee is responsible or authorized to sell the property. So you have one person kind of acting like the quarterback. They're selling everything. And then upon the sale, they have the beneficiaries that they distribute the property to. So, or the proceeds of sale to. So using a revocable trust is oftentimes a great tool to kind of streamline that process of selling property after someone passes away. Now we have Tiffany's presentation. Before or as Tiffany gets started, Jenny, if you'd like to introduce some polls for our attendees to take a look at. And without further ado, Tiffany, thank you again so much. And I'm looking forward to hearing your presentation. Please take it away.
Thank you so much. So just to touch on a little bit about probate and in combination with selling real estate, it doesn't have to always be complicated, but sometimes there are several layers involved depending on the complexity of the estate. How many, multiple heirs? Is it just the homesteaded property, etc.? But I'll go into just a couple details about that. Let's start with the current market conditions. So here in Broward County, as you know, sales have slowed down a little bit. About 11% from last year to this year. Generally speaking, we have a higher amount of cash buyers. Those have declined by 21% actually for single family homes. The median, excuse me, the median sales price is about the same, and the list to sold ratio has declined about 2%. The days on the market has increased slightly from average of 29 days to 38 days, and the inventory has increased by 34%. So there are approximately almost 6 months of supply, which would technically be a balanced market. However, if we're also combining that stat with condos, there are over 12.5 months of supply in condos. So we are teetering on a buyer's market in Broward County. So, all right. So things to know about property in probate and initial questions to ask. So when I meet with a client, the first questions that I will ask them are who are the heirs to the estate and who is the personal representative to the estate. It's very important to be working with the decision maker, as in a probate sale, there can be several different decision people combined ultimately that if there's like 4 siblings and a divorce, going back to what Lauren was saying. Also, is the property empty, or is, one of the spouses, like the new wife, living there? Is it full of furniture and personal items, or is it vacant? Is it a turnkey property? Is it in original condition? Is it full of furniture? Are these items valuable? If they are, do we need to auction these items and get valuations for these individual items? Do we donate, discard, or include them in the sale of the property? Have the heirs ever physically been to the property? So this is a great question, because I've had in the past a specific scenario where I was helping prep the property, and I was talking to one of the decision makers, the personal representative, and I said, hey, so what are we doing with this car in the garage? Well, they didn't even know that we had a car in the garage. So that was a great question. We were working with siblings, I think, were located out of state, and they've actually never even been to the property. So next slide. I'm just kidding. Here it is. Okay. How can heirs navigate and sell quickly? Well, here's an example of a pricing pyramid. It also comes down to selling price versus timing versus owner's motivation. So in this market, it's very, very important to price your property correctly, because as you can see, with any sale, especially in probate, when you price your property above market value, you will get about 15% of engagement versus if you price your property at market value or 15% below market value, you will get 90% of potential buyers will be interested in your property. And, a lot of sellers, almost every seller will say, well, we don't want to leave money on the table. But statistically, when you price your property correctly, ultimately it will result in a higher net proceeds for you, and you will sell the property more quickly. And you tend to get the most engagement in the first 14 days of the property's listed. So especially in our market, now that we're teetering a buyer's market. Comparative market analysis comes into play when pricing the property. The difference between, the list price, the appraised value, and the taxable value. The county will assess the property at a much lower value, which directly affects your taxes. So that's a huge benefit. Also, if your property's homesteaded, you will get a deduction on your taxes, $25,000 for an individual, $50,000 for a married couple. So another thing that could happen is there's a question on a date in the past. So there's many scenarios in which this can happen, but the question will arise, well, how much was the value last year in October for whatever the family history and scenario was of the property and time of death, etc. So that is called a retroactive appraisal, and that will determine the value in case, for example, let's say the market has tremendously increased. So doing a retroactive appraisal will accomplish a few goals. One is it will establish a defensible market value. One of the primary benefits is that it can help establish a value at a particular point in time. This is important for estate planning as it can help ensure that the property is valued for tax purposes correctly. If it is not accurately valued, the estate may be subject to additional taxes. Knowing the correct value will help the estate establish a baseline value that will determine capital gains, as you mentioned, when you sell the property. Another benefit is reducing the tax burden on the estate. It can help reduce tax burdens by establishing an accurate market value for the property. The estate planner can ensure that the property is properly valued for tax purposes, which can minimize tax liability and ensure that the heirs receive maximum possible inheritance. It can avoid litigation and disputes. There's lots of layers to this. The other factor in pricing is condition versus motivation. So if the property is an original property, it could be a distressed property because they've been living there for many, many years. It might need some updates. So with a single family home, sometimes the updates are optional. However, sometimes really there are recommended repairs needed to just move the property along more quickly. Maybe there are some property issues where in its current condition, it won't qualify for conventional financing. However, if you do some minor updates, you can open the pool of buyers to financing rather than just having to accept a cash buyer. So some of those things, we chat about. It's definitely a case-by-case individual scenario per property. And another thing to consider is, do the sellers want to do those minor or major renovations to increase their net proceeds? Because, statistically, if a buyer wants turnkey property, they're willing to pay more for it. So it could potentially benefit the seller's net proceeds. However, on the other side of the coin, if there is a hefty mortgage and HOA fees and carrying costs, this would probably deter a seller from wanting to spend more time on the property, and they would, tend to price the property more aggressively to trigger a quick sale, basically. Okay. So how can heirs navigate to sell quickly? So basically, step one is to hire a probate attorney. Specifically, SJF Law Group is incredibly knowledgeable and experienced. I know Lauren very well, and she's incredible. I'm not just saying that. So it is very important, especially in South Florida, to hire good quality professionals to make sure you're protected and being advised correctly. Also, your real estate professional, make sure they're very knowledgeable and experienced and familiar with the probate process. A third component would be your quality real estate attorney, because there are a lot of moving parts on the back end. There could be some items that have been overlooked just because the property's been owned for a long time, or depending on the unique scenario of each property, there could be outstanding code violations, liens, per diems from the city, open permits, and more, especially with the layer of the probate aspect. So it's very, very important to have that team in place while, deciding which direction to go, whether you're going to sell the property, rent the property, or, whatever your motivation is and ultimate goal. Also, pricing, prepping, and marketing goes back to, do you have a mortgage and carrying costs, or are you trying to maximize your net proceeds? When we take a property, definitely have a team in place to clear out the property. It does it, freshly painted is usually the biggest bang for your buck, can generate thousands more for you statistically. Getting it deep cleaned and prepped for sale. How many competing listings are there in the neighborhood that you are listing the property? That's a huge factor in pricing as well. So how to help families who live out of state and issues with delayed closings. So basically, if you are out of state, which many of these families are out of state because Florida specifically is known for people, empty nesters, people who retire, second homeowners, people who buy vacation properties. So it is very common to have a probate property in Florida with the heirs who live out. So basically the process is the same. We, handle everything from start to finish, from prepping the property to showings, to contract negotiations, inspections, appraisals, work. All of the professionals here basically have e-sign sessions, or we send mobile notaries pretty much anywhere in the country and the world to accommodate your needs, to walk you through the process. You do not need to be here for any of it. However, depending on your level of comfort, you can fly in for the closing, or if you're busy, you can sign from the comfort of your living room. The process pretty much remains the same. Can you list the property during probate? As Lauren touched on and mentioned, yes, you can list the property during probate, depending on how far along you are in the process. Ultimately, you do need court approval to sign the closing documents. But in our market, especially, in the frenzy, it was a little bit different, but in our market, things are taking a little bit longer to sell. So you can actually list it, market it, try to secure a buyer simultaneously, while on the back end, you're working on clearing all of the probate items so that it can lead to a clear path to sale, and you're not delayed more time for your closing. And that's pretty much it. Unless you have any questions, Laura and I are happy to answer.
All right. There are a few questions in the chat that I'll go over quickly before we conclude. So someone had put a question in the chat. Lauren mentioned restriction on devise is only for property in someone's sole name, but later in the third bullet mentions descendants get the remainder upon the death of the spouse. I'm confused. So let's go back to that slide quickly. So the homestead restriction on devise, it applies to homestead when that homestead is owned in someone's individual name, and they either invalidly devise it, meaning they leave it to the wrong person, or they don't do any planning, right? So I am a married person. I own my property in my sole name. I have a spouse, and I have, let's just, for purposes of this example, say adult children. When I pass away, or if I pass away, that property goes through probate, and the result is that my spouse gets a life estate in the property. They can remain there and live in it, use it. They can even rent it out and collect proceeds. And then upon the death of my spouse, the house goes to my descendants at that time. So I hope that clears up some confusion there. Another question is for sole homestead owners with adult children, what is the law? I understood the spouse and minor children can be the only heirs, but what about if there is only one child? So again, so for example, or let's use the example where a single unmarried person has adult children. There's no restriction. You can leave it to whoever you want because there's no spouse, there's no minor children. So you're free to leave it to those adult children or whoever you want, you know. Children, contrary to what some people think, are not, under Florida law, legally entitled to the property of their parents. The only people in Florida that have specific rights with respect to another's estate is spouses. Next question, can you have a ladybird deed inside of a revocable trust? Is that redundant? Which way is better, homesteaded property or second home? So a tool that our firm has been using lately is doing a ladybird deed with the remainder going to the trust. And that has proven to be a really flexible estate planning tool because during the person's lifetime, property's still in their sole name. So they can easily sell, refinance, mortgage, whatever they want to do with the property, it's still in their sole name. If they pass away, then it gets transferred to the trust upon death, avoids probate, and goes to the beneficiaries that they've listed in that trust. You can do that for any type of property, whether it's your homestead, a second property in Florida. This is specific to Florida property, but investment properties, it's often a great planning tool. And then the last question we have here in the chat is, what about the ladybird deed? Anything we need to know regarding whether it affects homestead taxes? So no, doing a ladybird deed, whether you leave it directly to someone or you use the ladybird deed to put the property into the trust, doesn't have any impact on homestead exemption, won't accelerate a mortgage, nothing like that. One last question came in. Can a ladybird deed be done with husband and wife? Yes. Yes, you can. So if you have any questions for myself or for Tiffany after this webinar, you can scan these QR codes to book a complimentary consultation with either of us. We are always available to answer any questions and guide you with anything that you're curious about with respect to the probate process, buying and selling real estate. Here's all of our contact information as well as a QR code to link with us on LinkedIn. And if there are no other questions, Tiffany, thank you again so much for joining us. It's always a pleasure to be with you on these webinars and always learning from you and hearing your insight about what the real estate and probate process is like through your eyes. And I want to thank everybody who attended our webinar live today and everybody watching who is going to watch this recording later on.
Thank you so much. It was a pleasure being here.
Thank you, everybody. Have a great night and feel free to reach out at any time. Thanks so much.